Any news on the lawsuit? No. There's no updates. Just waiting on a ruling. And I mean, it could be another 15 days or so. I think that'd be about 90 days. I can't remember exactly. What's the date today? It's now the 27th. Okay, so it's now been 77 days, I think, roughly 77 days since the hearing, which means that there's 13 days to go until 90 days. But there's nothing that says that you have to have a ruling within 90 days. There's no way to enforce it. You can request a ruling, but if you request a ruling from a judge, you may get them to put out a ruling prior to them having one. But 90 days is like it's like you can expect something around 90 days usually sort of idea, but it's not automatic. I was hoping to see something within 30 days. But we'll see eventually. Yeah, I'm really hesitant to say, oh, she might be reading into whatever, because you can't read into anything on how judges go. It could be based on their calendar. It could be based on anything. So, I mean, it could take 90 days for them to write a very, very basic opinion that just says, yeah, this is garbage, or this needs to go on. But yeah, so I don't want to read into anything based on any external factors. There's no way to do it. It's all speculation. Thought it would be open and shut, but that's fair. I mean, the thing that people may not realize is that a motion for dismissal or summary judgment that then has a response and then a reply, like that 3-step process, is open and shut. Like if we were to win at this stage, even though it took months and months and months, that's what an open and shut case is. The judge typically cannot sua sponte dismiss a pleading unless it is completely defective. The pleading would have to be completely defective on its face. And despite the fact that I think this pleading is ultimately defective, it's not facially defective. Like it is written in the proper form and format. It articulates some questions. So then at that point, you have to go through the process. Yeah, they have to hear it. I mean, just because if I don't answer, for example, even if they think it's garbage, then I make an admission by default to it. But by answering with emotion, like we're then asking the court to make a ruling. So in absence of that request for the court to make a ruling from my end, the other person has made a request for the court to make a ruling on theirs. And that's just the nature of lawsuits. They don't typically, if someone, goes ahead and files a complaint, they don't typically get just resolved unless it's resolved in favor of the complaint because the other person didn't respond to it. So that's the reality that you face with a lawsuit. If I was a judge in my own trial, what would I be thinking? I'd be thinking that this is obviously designed to as a frivolous attack on free speech, and that it should be dismissed for all of the reasons given. The next question I would have then would be, does this argument about the Colorado law and the application of its anti-SLAPP apply at this point? Because those are separate questions. Based on what is presented in the complaint and based on the principles of free speech, the fact that there are no factual disputes, this thing should be resolved in my favor. Like, I haven't said I didn't say what Monty accuses me of saying. It says, even if I said the things that Monty accused me of saying, they're not actionable. And they're not. Ultimately, these are opinions. These are protected opinions or hyperbole or jokes or criticism that is all protected under the First Amendment and jurisprudence. So, that's how it should go. If the judge says there's an existing issue of material fact, the question would be what? What issues survive summary judgment that a fact finder needs to resolve? That's what I don't understand. Because again, we know I said the things that were said. We know the dates that they were said. We know where they were published. The question is, are they I guess the issue of fact would be, is it defamation specifically? Not plugging the GoFundMe anymore, where was I tired of people whining? I mean, yeah, like I made the GoFundMe for people who wanted to contribute, and I feel like most of those people have. So I wasn't doing it to fund the lawsuit. Help defray the costs, yes, but I mean, the cost is way higher. The cost was already way higher than my original goal. So, wasn't that guy's case ridiculous on its face, though? Yeah, but ridiculous cases still cost a shitload to fight. Like, you can't just. This is kind of the problem with lawsuits in general. Is you still have to file a motion, they'll respond, and you have to reply to it. You have to gather and present evidence. All that shit takes time. It's so ridiculous. Couldn't you represent yourself? Yeah, if I represented myself, I would run some risks when like talking about it. I also wanted, to hire one of the people who's the absolute best at defamation defense in the country. So, and we did not get a hardcore liberal judge. I know the judge. I mean, a little. I don't know the judge, but I know the judge from work. I've worked with her on a couple different cases. She's like the elected judge around here, so for the county. But you can't I know the judge, so I know how they're gonna act on any of this. It's nothing like that. No, but I would really like this lawsuit off my chest, because it's stupid, but it's just this waste. It's a fucking waste. I have other things to do. It's just it's part of the gig, though.